Good afternoon. I think it's afternoon for everybody. It's even afternoon for me. Not legal advice. Please like, subscribe, share, whatever that other stuff is. Nice to have you on board. I wanted to bring you up to GTII because everybody is asking me, so I figured it was worth discussing. The reason why I was late a few seconds was I just literally, not figuratively, I was responding to an email from counsel who sued me. So I had given them the opportunity when they filed their complaint, amongst other issues, they didn't properly allege jurisdiction. So I brought their attention, agreed to stipulate to that as opposed to jerking around. And they were graciously thanking me for pointing that out to them. And now they're going to file an amended complaint. I don't know what the hurry is, but whatever. So I wanted to talk about GTI, and of course I will get into that. I wanted to make, this is obviously opinion only, since that's relevant on this particular matter. Before I start, of course, because it has to be the way it is. So good news and bad news joke. Boss goes to his male employee and says, I have some good news and bad news. The employee says, tell me the good news first. The boss says, you passed your drug test. And then the boss says, but the bad news is you're pregnant. Second, but not least, because I've seen this referenced a lot. I've seen people referencing it applies to today's status of GTII, that there's no buy button. That might be because the brokerages don't discriminate based on the basis of sexual orientation. So think about that one. And last but not least, GTII, where the term massaging the numbers gives you a different meaning, if you know what I'm saying. All right. So I think a lot of you have seen today, and I had gotten messages over the recent time about GTII possibly being delisted. And it was on the OTC. And if you all recall, back in 2023, I think it's April 11th of 2023, it was downlisted on the OTC from the middle level to the pink sheets. And people, I guess there was a notice that came out in this month based upon the fact that they hadn't done a hadn't provided current information. And if you recall, the problem with that related to that they had a prior auditor, and let's put it in proper perspective. So the current CEO, David Reichman, was the CEO, the CFO, and the chief accounting officer and a tax expert. He chose Borgers, which was the auditor. Borgers prepared the 2022 and 2023 financials. In 2024, in May, the SEC got rid of Borgers because they were a scam auditor. They had been cited, by the way, in 2022. One of their members, I think, had done 3 particular audits that were cited, and they being that particular member at least, was disciplined. So everybody knew about that in 2022. That should have included anybody from GTII. It should have included anybody who was a tax expert, because I think David was a tax expert or held himself out to be that way. So we get to Borgers being selected, I guess, selected or supervised, and not just my guess, about David. And that brings us up to the current time frame. So they didn't file timely their 10K. If you recall, there was a whole bunch of interactions. They said they were going to file it on March 29th, or no, by March 31st. It happened to be a Sunday. I got them to confirm that. They didn't file it on March 31st. They filed an extension, I believe, on April 1st. They filed their later 10K on the 16th. It had a bunch of information that we've talked about that had various odd information or information that at least raised questions that has not been answered. They then had a responsibility to file their quarterly reports, their 10Q. I think their next one, which was for the second quarter, they said it was going to be late. They haven't filed it. so they're not current in their information. Is that because of Borgers, because of the selection by David of Borgers? I don't know, because they also said they had to do an audit based upon Borgers' work. But remember, it was David apparently who chose Borgers. So if he chose it, and if he was a chief accounting officer and he was supervising them, then he probably should have been aware of those figures. And recall also that Mr. Rabari, who started December 1 of 2023, whose job was to set up a succession plan, which apparently was him taking over, and was supposed to analyze existing deal structure, supposed to help them remain compliant in their filings, and then introduce them to the market structure. That he should have been aware of this, I think. You know, if you're in that position and those are your responsibilities, and you're given the title eventually of COO, you expect that person to be aware of the problems with any accounting or anything like that. So that would have been effective December 1. And if you recall, Mr. Rabari was originally made, and just you have to follow these dates and information, and I'll get to the where we are today. Mr. Rabari was made the CEO effective in a meeting April 7th of 2024. They created a position of COO. He was supposed to take that position effective May 1 of 2024. He had been with the company apparently since December 1 of 2023. When the July 2nd contract and filing came out, the date of his starting as COO moved from May 1 to April 1. So before the 10K came out with all the interesting information. And his date as a CEO was, I think, effective August 1 of 2024. Those are the changes. So, but you'd expect somebody who was put in that position as of April 1 would have been apprised of this and would be able to take steps to either eliminate Borgers or do whatever needed to be done to make the filings proper. And I'm sure they would provide access to their auditors today to confirm that. I haven't seen that. I haven't seen an answer to any of our questions and answer to anything. Anyway, so we got into the point that I believed and others believed that absent intervention, legal intervention, this baby was going south fast. And I think by what's happening today, I think that's absolutely true, at least my opinion. Absent legal intervention, and we're trying our best here, and I'll bring you up to speed on that. I think this company and the stock would be going south, and it could be irretrievable to the extent that if nothing had been started as of today and the events of today had happened, it would be much more difficult to get up to speed. Because if you recall, complaint was filed June 27th through a bunch of legal maneuvers. We're waiting to get back to state court. We're waiting for the order from the federal judge, which I expect to be I'm hoping it's today, where this thing will go back to state court, at which time at state court, then the hearing will occur on the receivership. Per my discussion, now we're getting into the kind of today's stuff. Per my discussion or communication with counsel, one of the jobs of receiver, and they think that will be accomplished, is to the extent the stock has changed status, to get it back to its prior status. In other words, to uplist it. I mean, I'm using the term uplist it, but to get it back to at least pink sheet status. So what apparently, and I don't know for sure because I haven't seen a notice because we're not in management, but per SEC 15C2-11, that rule, which was amended, at least the amended version, September of 2021, if a company, publicly listed company, didn't provide current information that was publicly available, then public brokers could not quote the stock. So that's why people are having a difficult time getting, I think, transactions done, because they're not allowed to publicly quote. That doesn't mean you can't transact stock. That doesn't mean the stock ceases to exist. Just makes it harder to trade. And obviously that's not something we want to accept. And there is a market. It it does, it's called the expert market. It's for brokers and for accredited investors, etc. They could see the quotations. We can't as average investors. And part of what will happen here, once and if the receiver is appointed, they will then deal with that problem, and they will try to get it uplisted back so everybody can see a quotation, and it could trade back as usual, as fast as possible. Obviously, no guarantees. I've received multiple messages today, and had a conversation with counsel, and they believe that this is another fact that actually helps getting a receiver appointed. The fact that they haven't done what should be done. They haven't apparently provided current information publicly available to permit the quotation of the stock. I don't know. I don't know how that's defensible. And the fact that the attorney just reached out to me like 15 minutes ago on my matter might be because of that too, because that's very problematic for them. Also problematic for us. It really pissed me, to be honest, it really pissed me off when I saw what happened today. I don't know, as I said, it requires obviously legal intervention because these people are not going to do things easily. It 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 may be the case, and I'm just speculating, just speculating an opinion. If someone wanted to disguise or hide something, then a manner in which they could do that, they could let a company die. I don't know if these gentlemen are doing that in this particular matter. I don't know if they believe they have something to hide. I've mentioned that complaint that was filed in Nevada, and the shares that were and I'm just referring to that complaint. But the allegations in there were distributions of shares to all kinds of people. There was the distribution of shares to the mechanic and the masseuse, excuse me. So the masseuse and the mechanic, which should be a new show, right? A new show based in Las Vegas, the masseuse and the mechanic. We also had that transaction apparently where some entity was created out of thin air. $2 million was generated and split. Remember that? So maybe, and then we have if you looked at the 10K, there was the cash, the change in the cash position from 2022 to 23. And yet again, the problem here is there's been no explanation of anything. So to the extent there is a valid explanation for any of this, they could have provided it. They could provide it to it, notwithstanding the fact there are legal proceedings pending in both Nevada and now in California. They could provide answers. And before the legal proceedings were pending, recall, I got involved. I think I spoke to or communicated with these gentlemen, and I'm using that term very loosely, in February of 2024. Through April of 2024, I sent dozens of communications. I spoke with counsel, Mr. Fattel. I believe I spoke with Mr. Markowitz at least once. I spoke with Mr. Ribari once. No, none of the other directors returned calls or responded, but all of them received communications, and none of them at any point in time provided any information that contested any of the allegations. As far as I recall, no information, no responses to any email that contested any of the questions I had. Questions like, in 2022, you have this amount of cash, and in 2023, you have this amount of cash. So what happened? Those kind of questions. May not have been that specific question, but those kind of questions. The stuff that we are still asking about today. And so with all that being out there, and now, we know about their auditor being abolished by the SEC. We know about the stock distributions. We know about the issues, at least issues about cash. And we know now they didn't file apparently they haven't publicly filed information to keep them quotable. So with all that and without a response, what are we to conclude? I'm sure you all can conclude on your own, but I obviously have questions, and I've asserted what my situation is. So from this point in time, what's going to happen? What will happen from this point in time is we will get a new courtroom. We will go in for the receivership. There will be a hearing and an order, and hopefully a receiver and an injunction will be issued. And based upon that, a receiver, if that happens, then a receiver will step in to operate the business. So we're going to kind of take it one step at a time, because based upon that outcome, we would obviously, if the receiver wasn't appointed, we would look at it differently. Now, in addition about the receivership, and I'm just going to respond to the question. So is it delisted? It's not delisted. It's still there. The shares still exist, just not quotable. So it moved because apparently, because current information was not publicly available. So, and because of a SEC section that was amended in 2021, 15C2-11, because of that section, because apparently they hadn't filed their 10Q and because they were given notice and didn't provide it, it was put to the expert market, which restricts quotations to the public, but the stock still exists and is still transactionable, just makes it more difficult. And as I indicated before, what a receiver will do, and kind of one of my questions was to counsel this morning when I found out about this, is what is the receiver going to do? And the receiver, one of the things the receiver is going to do is ask that the downlisting be reversed and it be uplisting. And now they may ask also beyond that, because if we recall, back in 2023, it was downlisted from a different status at OTC, and we may try to get that uplisted. So I'm looking at questions. Yes, a lot of shareholders, I agree. I'm going to put this up here. I think a lot of shareholders are hoping that the receivership is granted because they have lost faith, at least myself. I mean, why? What is that is occurring today gives you faith in current management? I don't know. Maybe others have a different view, but made me wonder, especially considering, again, I looked at that April, I think there's an April 9th PR. An April 9th PR, one of the tenets of that is why they're describing why they hired Ribari is staying with the, and this is not the exact wording, but it was something to the effect that he would help them stay with the mission statement of being compliant in their filings. That's April 9th. And he was CEO apparently as of April 1st, even though it said May 1st, but apparently he's CEO as of April 1st. So I guess that makes him responsible for late or non-filings. Then we know that the way they kind of try, and this is just my opinion, the way they tried to cover it looks like that indemnity agreement where Ribari comes on and he gets indemnity. In other words, he gets protection. So if he gets sued, they cover the cost of the fee, the cost of the litigation, et cetera. And that way, seems like, maybe not, but seems like that might be inducement. But what people don't understand. So an indemnity agreement is where somebody else agrees to be responsible for your legal claims. So if someone, in this case, let's say in the Nevada action, the case is amended. No, this is purely hypothetical. But let's say the case is amended and Ribari is now named as a defendant because he was there since April 1. So now he's responsible for the acts. And why didn't he fire Ribari why didn't he fire David if he thought there was inappropriate conduct? So if that was what he thought. But if that's the case, he'd have an indemnity agreement. And the indemnity agreement basically says if you get sued, the company will take care of you and defend you and cover your liability. But the company doesn't have any money, so who would do that? Would that be David? But so let's say, for the sake of discussion, let's say it's not GTII, but David, and let's say he's indemnified. This is all speculation, of course. So let's say David has indemnified all the officers and directors, including Mr. Ribari, and said, if you guys get sued, I'll cover your legal fees and I'll cover any liability so you guys can relax and you're safe. And I've heard allegations, by the way, that was done, notwithstanding Ribari's indemnity agreement. Rabari's indemnity agreement is in a filing, so it is stated. But I've also heard through the grapevine that maybe the other officers and directors also have that. And in the Nevada action, they were named, and obviously there'll be witnesses in my action if it stays that long. And they believe that they've been promised indemnity. But think about it this way. So what's indemnity? Does indemnity guarantee you that your fees will be covered? No. It's a promise that your fees will be covered and a promise that a judgment will be covered. So if I get a judgment against, and I'm just making this up, so this is just not factual, this is just speculating. But let's say someone named Kathy Griffin was a director. And let's say in the action in Nevada, there was a judgment received against Kathy Griffin. And I don't know if that's going to happen, but let's say that happened. And let's say David Reichman had given her an indemnity agreement. And she then, again, just speculating, she then went to David after there's a judgment and said, hey, David, please take care of my judgment. And how about if David, who had already spent a bunch of money in legal fees, said, no, sue me? Have I ever seen that kind of situation? Yes. So somebody who has indemnity might not have anything other than a right to sue anybody. Their legal fees may not be picked up, and certainly a judgment may not be cared for. And if I'm the attorney and I get a judgment against X, I don't care that he has an indemnity agreement with somebody else who says they're going to take it up. Unless that person writes me a check, I go after them. So all these people, to the extent they have indemnity agreements, and to the extent those indemnity agreements are prefaced on somebody like, for example, David Reichman making good, that's a lot to rely upon. And if it's not David Reichman who's responsible, who is it and why? I don't understand, part of this whole GTI business related to some people, and again, I'm not one of those, by the way, but some people believe that and their interest relies upon the short position. And so if that is the case, and I know I saw some document that reflected the dedicated short position from SRO reflected in Alpine, et cetera. I've seen that all before. So, but you wonder why everybody is involved, and of course you wonder why Rabari is involved in this matter at all. I understand that he's being provided shares, but if the shares have very limited value, and if you're buying into a mess, I don't get it. If you recall that one provision in that contract in which he's hired, and after he then would be in both position of CEO and COO, GTI has the option to buy 10% of his company. I don't know if that's a up and up deal, and I don't know if that's a way of somehow protecting Mr. Rabari. I don't know, because I know he would be in control of both companies at that time, but it struck me as interesting. So summarizing, and I'm just taking a quick peek to see if there's any other questions that might apply to what I've seen. And I know people are having trouble with their brokers. They're having trouble with the brokers because of the status change or parent status change from pink sheets to expert market. It may be that they are able to transact business in the future. It may be that the brokerages are trying to figure it out. But I don't know. Bankruptcy does not, somebody wrote a bankruptcy. Bankruptcy just shifts, that's a good question though. What happens if somebody files bankruptcy? Does that discharge their obligations? So of course, this is not legal advice. I'm not a bankruptcy attorney. I just play one on TV. I've seen it. Fraud is not dischargeable. Intentional misconduct is not dischargeable. To the extent that someone tries to escape through a bankruptcy, it would just create additional litigation in bankruptcy. Is that complicated? Yes, of course it's complicated, but I've discussed that with counsel already, so it's not like that's a a non-issue. The other thing, and again, this is a bigger issue, and I've thought about it. I spoke to little JR about this, and it might provide like the strangest opportunity. So what happens if there was a bankruptcy filed? Well, we can go to Sorrento Therapeutics. And if you guys want to check out Sorrento Therapeutics, in Sorrento Therapeutics, a Chapter 11 was filed because of a bunch of some legal action, and the company ended up on the wrong side of the legal action, although not terribly, but they ended up short on money. Filed Chapter 11, company got heavily shorted. In the Chapter 11, the court, at the bankruptcy court, made the brokers disclose their short positions. It proved that they had too many short positions. The court then, through a process, set up an operation whereby the shorts that were, in essence, counterfeit shorts could close. The price was generated based upon an agreement using, I think it was a 3-person team, 2 from the company, 1 from the creditors, or I'm saying 1 from the shorts. So the price was a reasonable price. They didn't disclose any of this. It was all confidential. So the brokers just disclosed the amounts, but who the short positions were and how it was remedied was not disclosed. But that was done within the bankruptcy. And I've been waiting for an opportunity to test that. And so if any of these slugs want to go in there and attempt it, I think I would encourage highly an action against the shorts within the bankruptcy to go after that. So in terms of bankruptcy filing, I'm not a bankruptcy attorney, et cetera, again, but I think it would provide other opportunities to go after other potential assets for GTII. So even though it sounds terrible, it's no worse than the position we're at. And I think it opens up avenues, because without the bankruptcy proceeding against the shorts, obviously is difficult if they exist. So that's the answer to that about bankruptcy. So bankruptcy just is another forum. It might be a way of buying time, but it also, at that point in time, think about this. To the extent somebody has a bunch of assets, they may be exposing their assets. And I don't know about Mr. Reichman's position, but I think some of those people do have significant assets that might make them not only a target in the action in Nevada, but might make them a target in the bankruptcy. So that's the answer to that question. So unless, I'm just looking over the questions, if anybody else has any questions, put them up there and I'll answer anything. Absent that, I will keep you apprised, let you know when we get the order back from the federal court, when the receivership action is set up, and when the hearing is, and where we are. And obviously, if anything changes with regard to the status, other than that, I mentioned about the expert market that they're in right now, which again is only for brokers and accredited investors primarily. And only they who see the quotations, but the shares still remain tradable. But it's harder, obviously. But if that changes, obviously I'll let you know. And we obviously encourage them to do their filings to make everything current. So, and to do whatever they need to change the status. Now I'm referring to current management to do that. And I will keep you apprised. I expect this stuff to happen in the next couple of days or so, and we'll keep you apprised. If you have any, yeah, looking for a good massage therapist, I understand. If you have any questions, because I'll post the video. If you have any questions other than what I've addressed, feel free to reach out, and I will try to give you an answer. Obviously, like I said, it appears to me that the assumption was correct that if we had not intervened, this company would have gone south for the summer, because it looks like that's where it has gone. And I'm glad we have at least taken action, and I'm very hopeful, although no guarantees, of course, but hopeful that we can turn it around, and I'll keep you apprised. That's all I could say. Anyway, be well. Sorry for all the stress and fuss, because I know it sucks. Really, I found it really annoying. And remember, I'm getting sued in this on top of this too, just as the cherry on top. So everybody be well, take care. Again, put any questions you want. Talk to you later, and I'll keep you apprised of any new information. Again, we're just waiting for the federal court order and then the hearing on the receivership, where it will be. Thanks. Take care. Have a great day.